Have you ever wondered what happens when a testator names heirs in a will, and how these heirs might be replaced if they are unable to inherit? Understanding the intricacies of institution and substitution of heirs is essential for navigating estate planning and inheritance laws in the Philippines. Factual introduction. Institution and substitution of heirs is a critical topic under the new Civil Code of the Philippines, particularly covered in Articles 840 to 870. This topic often appears in the Philippine bar examination and is crucial for bar examinees, law students, and legal professionals. It deals with the mechanisms by which heirs are designated and replaced in a will, ensuring that the testator's intentions are honored even when unforeseen circumstances arise. By mastering this topic, you will gain a comprehensive understanding of how testamentary succession operates, which is essential for advising clients, drafting wills, and resolving inheritance disputes. This knowledge is invaluable not only for passing the bar exam but also for your future legal practice. To stay updated with our latest content and continue enhancing your legal knowledge, make sure to subscribe to our channel. Hit the notification bell to get notified whenever we post new videos.
Institution of Heirs. The institution of heirs refers to the act by which a testator designates in his will the persons who are to succeed him in his property and transmissible rights and obligations. This is provided for in Article 840 of the new Civil Code, which states, Art. 840, Institution of Heir is an act by virtue of which a testator designates in his will the person or persons who are to succeed him in his property and transmissible rights and obligations. When a person makes a will, they specify who will inherit their estate. This designation is known as the institution of heirs. The testator can name one or more individuals as heirs, and they can be given specific portions of the estate or particular items. Substitution of heirs. Substitution of heirs comes into play when the originally designated heir cannot or does not want to accept the inheritance. The new Civil Code provides various types of substitutions. 1. Simple or common substitution, Article 857. 2. Brief substitution, Article 859. 3. Fidei commissary substitution, Articles 863 to 870. Simple or common substitution. Article 857 defines simple substitution as follows, Art. 857. A testator may designate one or more persons to substitute the heir or heirs instituted in case such heir or heirs should die before him, or should not wish, or should be incapacitated to accept the inheritance. In simple substitution, the testator names an alternate heir who will inherit if the primary heir predeceases the testator, refuses the inheritance, or is legally incapable of inheriting. This ensures that the estate will not be left without an heir.
Brief substitution. Article 859 covers brief substitution, Art. 859. Substitution is also brief when the substitution of the heir is limited to the case where he dies without issue before the testator. This form of substitution applies when the primary heir dies without descendants before the testator's death. The substitute heir then steps in to inherit the estate. Fidei commissary substitution. Articles 863 to 870 elaborate on fidei commissary substitution, Art. 863, a fidei commissary substitution by virtue of which the fiduciary or first heir is instituted to the whole or part of the inheritance, with the charge to preserve and transmit it to a second heir, shall be valid and binding, provided such substitution does not go beyond 1 degree from the heir originally instituted. Fidei commissary substitution involves a fiduciary heir who inherits with the obligation to preserve and subsequently pass the inheritance to a secondary heir. This form of substitution ensures that the property is preserved within the family or intended beneficiaries. Conditions and restrictions. Substitutions are subject to specific conditions and limitations to ensure they are legally valid and enforceable. Some of these include capacity of substituted heir. The substitute heir must have the legal capacity to inherit. Existence of condition, if the substitution is conditional. The condition must be fulfilled. Validity of the will must comply with all legal requirements for it to be valid. Conclusion and call to action. Mastering the institution and substitution of heirs is indispensable for anyone involved in the legal profession, especially those focusing on estate planning and succession law. This knowledge will not only aid in passing the bar examination but also prove invaluable in legal practice. Remember to subscribe to our channel to stay updated with our latest content and continue building your legal expertise.
Frequently asked questions. 1. What happens if the primary heir refuses the inheritance? Answer. If the primary heir refuses the inheritance, the substitute heir named in the will inherits the estate. This is covered under Article 857 of the new Civil Code. 2. Can a testator impose conditions on the substitution of heirs? Answer. Yes, a testator can impose conditions on the substitution of heirs. However, these conditions must be lawful and possible. The conditions must also be fulfilled for the substitution to take effect. 3. What is the difference between simple substitution and fidei commissary substitution? Answer. Simple substitution involves naming a substitute heir to inherit if the primary heir cannot or will not inherit. Fidei commissary substitution involves a fiduciary heir who inherits with the obligation to pass the inheritance to a secondary heir after a certain period or upon fulfilling specific conditions, as outlined in Articles 863 to 870 of the new Civil Code.